Good morning, everybody. Can everybody hear me?
I can hear you.
Brilliant. All right, so in the interests of keeping this simple, I'm content that just the people that anticipate speaking today have their cameras on. That's okay. So just to explain who I am and what we're doing here, my name is Holly Nichols and I am the inspector appointed by the Secretary of State to conclude this inquiry and to determine the appeal made by Nicholas King New Homes Limited, and that is against the refusal of permission by the Vale of Whitehorse District Council. And that's for a scheme of up to 249 dwellings in outline form with detailed access and all site at land north of Spring Hill, Kingston Bagpues with Southmore. This is day 3 of the inquiry. We opened on the Wednesday, the 24th of June with our formal openings, the input from the interested parties, and the roundtable session on housing land supply, and our accompanied site visit. On Thursday, we exchanged the planning evidence formally, and then we adjourned. During the adjournment, the main parties and I have exchanged emails on a without prejudice basis on the planning conditions and on the Section 106 planning obligation, and that is in the interest of expediency. We do have a roundtable discussion on outstanding matters in relation to planning conditions and the obligations this morning, first of all, and we will also be hearing the main parties' closings, hopefully. So what we'll do then is we will have a quick reintroduction from those that anticipate speaking this morning to deliver the closings and also to input into the Section 106 and planning conditions roundtable discussion, please.
Yes, good morning, Mum. My name, as you recall, is Sasha White, KC. In relation to the condition session, Mr. Duval will lead on behalf of the appellants. He will be assisted by Mr. Will Varell and Mr. Tom Mitchell, who are from the clients, but Mr. Alan Duval will lead. And then on the Section 106 session, you have the presence of Mr. Khan, who is the instructing solicitor of the appellants, who has drafted the Section 106 that you've seen.
Thank you. And what practice is Mr. Khan from, please?
Mr. Khan is from a practice called Knights, whose address I hope you have in correspondence, but if not, he can send it in to the case officer.
Okay, thank you very much. Good morning, Mr. Khan, Mr. Mitchell, who I've not met as yet. And for the council, please.
Good morning, Emmeline Lambert, counsel. On the condition session, Miss Tracy Smith will be leading for the council. Mary Jane O'Neill is also on the call and may take part. Also here, Madam, are officers from Oxfordshire County Council who may have input in relation to conditions in the Section 106 agreement, in particular Catherine Hamer and also Claire Bennett, as I understand it.
Okay, could you please explain to me their respective disciplines, just so I understand that?
My understanding is that Catherine Hamer is from Highways and Claire Bennett has, I'll get her title wrong, but it's overall responsibility in relation to contributions and obligations. Ms. Bennett, maybe you can explain, sorry.
Yes, good morning, Mum. Yes, that's correct. Ms. Lambert, yes, that's good. I can cover the non-transport matters for the county, and Ms. Hamer can be responsible for any questions she has for transport matters.
Okay, well, good morning both. Nice to meet you as well. Thank you very much. All right, so let's start with housekeeping matters. In terms of documents that I've received, we're going to go through those and just list those so that you understand what I have and what inquiry document reference I'm giving them. So obviously last week we had ID 7, which was the planning balance table. Since then, I've received two further versions of updated working draft lists of planning conditions, and I've given those each a respective ID reference 8 and 9. I had an email about the archaeology condition, which I queried. So in the interest of transparency, I've also given that email reference ID 10. I had an email about the indexation uplifts in the section 106, and that has been given document reference ID 11. And then something occurred. I received a document, which obviously I have since received an email from the appellant to which it's got strong objections to its acceptance. So I think that's this is an opportunity to discuss what we're doing with that, if that's okay.
Yes. Madam. The council sent you a draft pro forma yesterday with a covering document from Ms. Reid. It related to the site with reference 1735 Crab Hill. You will recall that was a site that was discussed during the Housing Land Supply Roundtable. The information became known to Ms. Reid while preparing for another inquiry. It became known to her on Friday. That's why it was sent in late. Regarding the lateness, it is submitted that that is a reasonable explanation for the lateness and a reasonable explanation for why it came in after the evidence had been heard. You will recall there was a debate about the site not yet taken to the market, and there was discussion about what that meant and whether further reserved matters application would come forward in relation to a phase of that site. The pro forma recently received confirms that that phase is to be brought forward by Vistry. In the council submission, that deals with concerns that the appellant had regarding the site. It does not relate to revising the housing land supply position. There's no recalculation that needs to be undertaken. It doesn't relate to a new base date because this is not a new site that the council is seeking to be slotted in to its housing land supply at the moment. It is information regarding a site that is already in the housing land supply. And the evidence that the council puts in, it says, supports that position. The council submits it's relevant to your determination and that it should be admitted. And its admission is a matter for you. In relation to an email, I haven't seen the email that was sent to PINS this morning, but my learned friend did email me this morning outlining the appellant's strong objection. He noted things like the fact that the council had given no prior notice of this to the appellant, and for that I apologise. It came to the attention of the council late, and the council simply wanted to send this in as soon as possible. My learned friend also referred to the fact that Miss Reid referred to the base date during her evidence, and therefore this evidence contradicts evidence that she gave to the Housing Land Supply Roundtable. The response from Mr. Neame, if you remember, Madam, was that information can be relied upon post base date. Housing Land Supply is a snapshot in time, and this evidence goes to that snapshot. My learned friend also raised with me that the pro forma is in draft form, and that is right, it is in draft form. In my submission, that's a matter that goes to weight, not to relevance. And so, Madam, the council's overall position is that it should be admitted. It's a short document. It doesn't require adjournments or evidence to be reopened. In my submission, it can be dealt with swiftly and easily. Thank you.
Okay, Mr. White.
Yes, ma'am, I will make some submissions, but I would like my learned friend to confirm. What she's confirmed is that Miss Reid became aware of it on the 29th of June, which is Friday. But I would like her to confirm when the LPA, it's a pro forma that obviously would have been received by the council. Miss Reid is an external consultant, so I'd like my learned friend to confirm when the council received the pro forma, because obviously we had the HLS on earlier in the week on the Wednesday on the 27th. So that's a factual point. I'd like my learned friend to come back and tell us. But in terms of my submission, ma'am, as you know, I think my starting point, please, could you, I don't know if you've got a copy and you've got access to the internet, but I would like to go to the PINS guidance, please, on appeals, because at 11.14 this is dealt with in terms. So could I ask you please to just take up it's 11:15 late documents, and the advice that PINs give that where there is a change in circumstance. Do you have that up, 11:15.3?
I have 11:15.3. Yes, I have that. Yeah.
11:15.3 talks about if there's a change in circumstance, we will consider accepting late documents. And then at 11:15.4, this is relevant for you. The guidance is the inspector will only accept a late document if they are satisfied that, and there are 3 criteria, and in my submission, they're clearly all need to be satisfied. The content of the statement is not covered in evidence already received. 2, that it's directly relevant and necessary for their decision, and 3, that it would be procedurally fair to all parties. Well, for the reasons I'm about to say, it certainly doesn't satisfy the second and the third bullet points, because what the council have done is we know that it was received on the 29th of June. Well, Miss Reid was aware of it on Friday. What my learned friend hasn't explained in any way, we were put on notice about this at 5:50 yesterday afternoon. Now, I understand, and there are personal reasons that Miss Smith set out, which are completely understandable, but there's absolutely no explanation from the council why Miss Reid, upon receiving it, or my learned friend, didn't feel able, and at least, I mean, we've had effectively 3 days, albeit 2 not working days, but it's admitted by the council they knew of it on Friday the 26th of June. So there's no explanation for why we were only notified by it at 5:50 last night, frankly. So that explanation needs to be given, and that's the relevance also of when the council had it. So there's no evidence or justification for why it came so late in the day. At least 1 and a bit working days, the council failed to notify us that they had this document, and they failed to notify us why they were going to seek to rely on it. And to put it in at 17:50, I mean, what my learned friend hasn't addressed is how she expects you, or more importantly for you to have both views, how she expected the appellant to deal with it, because we, as you know, the only 3 things on the agenda this morning were to deal with the conditions and the section 106 and closings. There's no facility in the timetable whatsoever for the appellant to deal with this, and my learned friend has given no indication of how the LPA expect us to deal with it according to the timetable that we all agreed to, or how you were expected to deal with it on the timetable that we all agreed to. So the first problem we have is that, in the interests of fairness, at the moment, it would obviously be grossly procedurally unfair on the appellant for you to accept it, because there's no ability for us to deal with it in the light of the timetable that we all agreed on Thursday afternoon. And there's been no application by the LPA to change that timetable. In the email that was sent to you yesterday, there was no suggestion of how it should be dealt with whatsoever. So the first major issue is we have a problem because the LPA have put this evidence in. They must accept the proposition that we have the right of reply, but they have no suggestion of how that takes place, and they made no application to you. My learned friend has made no application to you how she suggests we deal with it, which is extremely peculiar. So we have a major issue that this constitutes a breach anyway, because it is late evidence. We had the roundtable on Wednesday, and as you know, Ma'am, unless one brings these things to an end, there lies madness, because imagine if we had taken the same approach and basically sought to put in additional evidence that supplemented that was on Wednesday. You wouldn't be able to close the inquiry. So the LPA are seeking you to take a step, frankly, that's extraordinary and not in accordance with the rules, because they have sought to provide fresh evidence. I assume the justification is this is the contents are not covered in evidence already received. And it seems implicit in what my learned friend is saying, that is the basis of the application to submit it. So we're in a world where, frankly, the council are seeking to do something out of the ordinary by submit new evidence, not in accordance with the timetable, not identified. At no time was anyone told that they would seek to produce new evidence. And then can I finally deal with the substance? We're deeply unhappy with its status. It's in draft. It's unsigned, ma'am. It's got no, it's completely unsigned. I also want an undertaking from my learned friend that there aren't other pro formas that she'll seek to submit before we complete the inquiry. And I also make the point that we don't accept the proposition put by my learned friend because it was accepted, frankly. The whole basis of the HLS on last week was on the basis of agreement, as you know, of what the period for consideration was, which is 25 to 30. This is evidence that the council have got expressly in the context of the update to the HLS position with a 2026 base date. So it completely contradicts what the agreed position was, because again, imagine if the appellants and the council both sought to now effectively put new evidence on the first time yesterday afternoon, which addresses, frankly, a new period, 26 to 31. I should just deal with an additional matter which is relevant. If you are minded to accept it, and for the reasons I previously said, I ask you strongly to reject it, but if you were minded to accept it, obviously that would necessitate us having the right to reply. We would want at least till this Friday to reply. And I'm putting my learned friend on notice because, frankly, what has been done is utterly unreasonable. That any time that Mr. Neame takes in dealing with this, any time that Mr. Duval has an input into as the overall planning witness for the appellant, and any time I take for reviewing it, would lead to a partial application for costs of unreasonable behaviour from the LPA. Frankly, because what is being sought to be done constitutes, in the clearest terms, unreasonable behaviour, the submission of late evidence out with the inquiry timetable without notice and causing the appellant to do additional work. So that is my submission, ma'am. So fundamentally, I ask you to just bring this matter to an end and reject it, which is within your discretion, frankly. And that would bring the matter to a close. If you do accept it, then we ask for the time period till Friday, and my learned friend and those instructor can expect, and we will make an application for the cost that we spend on this matter as it constitutes unreasonable behaviour. So that's the position of the appellants, ma'am.
Okay, that's understood. All right, Ms. Lambert, do you want to have a 10-minute adjournment to take instruction from your client on how to deal with this or how to respond to some of the points raised by Mr. White?
No, it's not necessary. It's not necessary, madam. Mr. White had fairly sent me an email that did cover most of those points that he made. The only point that wasn't covered was how much time the appellant would need to deal with it. As to timing, what I was going to say is we do have a reserve day tomorrow and closings could be pushed to tomorrow. The council could accommodate that. As to a new housing land supply period, as I've said, it doesn't go to a new housing land supply period. It is not a new site. As to time to reply, my learned friend saying that the appellant needs until Friday, the council's position is it's a very short point. That seems like a very lengthy period in which to respond to a very short point. In my submission, the appellant could deal with it today and closings could be moved to tomorrow if further time is needed. Madam, that's the position of the council.
Mom, could I just come back on a couple of points before you reach a view? I'm not suggesting in any way we adjourn. I mean, in terms of the substantive hearing, if we put a written response in, we can close the inquiry today. We do not want to adjourn, frankly, because you can imagine we've all made arrangements. I'm due to be in Surrey tomorrow with 25 people, so I'm certainly not, my anger would get even more excessive if the answer to this is changing the date of closings, frankly. But what I do want, and I think it's incumbent upon you to ask, because it does go to you in my submission whether you should accept this. My learned friend has not answered, and she needs to answer. What we know is that Miss Reid was made aware of it on Friday. There are two matters which I think it's incumbent upon my learned friend to answer. First, when the LPA got the information, because it would be highly pertinent if that pro forma was before the LPA prior to the HLS session. Point one. Point two, I do want to understand why Miss Reid, there is this gap. Miss Reid admits she knew of this information on Friday and no one was told about it till 5:50 last night. And I'm afraid my learned friend needs to explain what happened in that window as to why, frankly, we were only told about it after close of play yesterday, when it's admitted that the council knew of it and Miss Reid, an external consultant, knew about its existence on Friday the 26th. So I do think before you reach any judgment on this, that Miss Lambert needs to answer the questions of when the council received the pro forma, and two, what happened in that window, which is currently completely unexplained, between Miss Reid knowing about its existence to 5:50 yesterday afternoon.
Sorry, I should have dealt with that. Madam, the email was sent to me yesterday by Miss Reid notifying me about the pro forma. I'll check exactly what time it was sent to me. I think it was the afternoon. She said in her email to me that she did not know when the LPA had received it. That was just, she had just received it on Friday. She doesn't work on Fridays. So although she had been made aware of it on Friday, she doesn't work on Fridays. So yesterday really was the first working day that she and the team could deal with the pro forma. I don't know why it was why the email wasn't sent until 5:50. Mr. White referred to some explanation given by Ms. Smith in the email. I don't know anything about that, I'm afraid. I'm trying to find out about when the LPA became aware of the pro forma. That I need time to take instructions on, because as I say, Ms. Reid didn't know and didn't put that in her email to me. So I need time to take instructions on that. I may not find out in the next 10 minutes.
Okay, Ms Lambert, you've heard the suggestion that the appellant's team wants to continue with closings today, but if it were required to deal with this small point, that it would want to do so in writing on Friday or by Friday. So what are your thoughts on that?
That seems fine.
Obviously, you've been put on notice about the potential cost implications of its acceptance and the time spent dealing with it by that deadline. I think that might be the most pragmatic way forward if you insist that I accept it.
Yes, the council's aware of the possibility of the application. Again, my learned friend had made me aware of that. Instructions have been taken. The council's aware.
The only question that raises then is, when will that cost application be made? Because typically it's supposed to be before the close of inquiry, and it doesn't seem easy to do that because we don't even know what the costs implications are for the appellant. Obviously, we know the nature of what is expected and who is going to be working on this response, but the cost application looks like it's going to need to follow at some point. Mr. White, how are you anticipating submitting a cost application?
Mum, I was going to suggest we do it. We have a timetable in writing. I would submit the cost application by, say, next Monday, with my learned friend having till, say, next Thursday to respond, and it would all be done in writing. I would not want to incur, it would be madness to have an oral session on the costs, which would probably exceed the amount that's claimed. So we'd be adding cost to cost, and also we would see any oral session, we would seek those costs as well as directly linked, frankly, to the determination of the council to have this evidence in. So could I suggest, which, as we have raised and dealt with quite a lot of issues, and my learned friend has identified she needs time to consider or get instructions, could I suggest, in the interest of expediency, that we deal with the 106 and condition session now, because this matter does not affect that. and that when we've completed that, just prior to closing, we return to this matter. My learned friend might have got instructions to answer the 2 questions I've posed, and it will also be gently percolating in your mind as to what your preference would be as to how to deal with this. And my learned friend might also have, those listening to me from her side might also have views on how best to go forward. So my suggestion, to ensure we don't lose too much time, is to park this, do conditions on 106, and then have 5 minutes at the completion of that before we commence at closings, just to finish this point off, and you can make a ruling as to how you would like to proceed.
Okay, that's fine to me. All right, so moving on to the planning conditions and section 106 session then. I have obviously circulated some comments, so focusing on the conditions first, I am grateful for the updated list which separates the plan's conditions into 2 lists, one which is strictly for approved plans and one which is for plans with which general compliance is accepted or substantive accordance is required because of the nature of the outline application. That is fine from my perspective now. I don't have questions about the conditions until we then get to the archaeology condition. I haven't had much of an opportunity to review that email that was submitted, but I would ask for the appellant's team to confirm whether it has any revised views on this condition or conditions on the basis of the input from the archaeological officer, please.
Good morning, ma'am. Thank you very much. The schedule that was obviously circulated to you sets out our position in terms of we've undertaken a considerable amount of archaeological work on the site, including significant trial trenching previously. We've obviously received the email that was received late yesterday. Unfortunately, because of the time that it was received, we haven't been able to get a response from Oxford Archaeology, who were my client's archaeologists that undertook the work, all of the detailed work on the site. Everything from the geophys work, the WSI, and like I say, the detailed trenching on site. So our position remains that we have undertaken considerable work in terms of that trenching work on the site. We're happy to accept a condition that requires us to obviously raise with the County Council anything that becomes apparent during the construction works in terms of archaeological finds. But I think our concern still lies with the requirement to undertake further trenching work. I don't know if Mr. Mitchell or Mr. Farrell wants to add anything further to that.
Morning, Madam. Tom Mitchell, Nicholas King Homes. Just to add to that point, as Mr. Duval suggested, we haven't taken specialist advice. The only point I would add to that is if you were so minded to carry on with a condition or conditions, the content of the Oxfordshire County Council response does make specific reference to a small portion of the site where there was some findings of a lower level of significance. So whilst our general view is we think quite an extensive amount of work has been undertaken, should you be minded to retain a condition, we would feel that would be best placed being more specific to the parts of the site where investigations to date did make small findings, and that it wasn't an open brief that gave the council sort of undue reach to require full site-wide investigations through condition again.
Okay, is there anyone on behalf of the council that wants to provide anything further on that particular condition?
Can I just clarify? a few matters, Mum. Did you say I was going to be able to come in? Sorry. Okay.
Yes, of course. Yeah.
Whilst I've got the floor, yesterday afternoon, my dad has got Alzheimer's. We had to find him a care home. So that's why yesterday afternoon went a little bit pear-shaped, and I wasn't able to send the correspondence on. So I just wanted to send my apologies for that.
Miss Smith, whilst you're here, thank you for participating today. It does sound like you've got quite a lot going on at home. I apologise for the stress that this is causing you, and I'm really sorry that the timetable is so inflexible.
No, it's fine. It's fine. But I just wanted to clarify that and get that out of the way and apologise. But in terms of the archaeology comments, I asked, these were known to the appellants because we've been discussing the conditions previously, and I'd had a response from archaeology which had simply said, please refer back to our consultation comments. So they were aware that archaeology was sticking with their comments. I just asked for this email from Oxfordshire Archaeology to reconfirm their position and put everything in one place rather than having to cross-refer back to comments. So this is nothing new. My email yesterday sent at 16:05 confirming Oxford Archaeology's comments. It's nothing new. It's been known to the appellant. So I just wanted to clarify that too, that we aren't sort of Oxford Archaeology aren't making something new known to the appellant in terms of what's been done. There's Oxford Archaeology been consistent in the need for their conditions for this scheme and their reasoning for that.
Okay, understood. Was there anything further, Miss Smith?
No.
Okay. All right. Anything further on behalf of the appellants on this condition?
No, ma'am. Not from myself.
Okay, I think that's one that it's something that I'll have to have a look into and decide on the best approach.
Okay, thank you.
Then I don't have any conditions until we get questions on conditions until we get to, so conditions 23 and 24. Don't have an issue with 23, which is foul drainage capacity. 24, network water upgrades. Is that required because there's like infiltration-based subsystem that are discharging to a combined sewer or something? Why do we need, what's the network water upgrades, or is that to provide water supply for the dwellings?
That's my understanding, Mum. And it's consistent with another development we've got in not too far from this site in Drayton, where there are similar issues that Thames Water have flagged with us. So, yeah.
Okay. And you will have to accept my apologies for not being familiar with the timetable on this then, but have the consultee provided an indication that this improvement upgrade programme is underway and or will deliver in the timetable that works with the appellant's conditions on submission of reserve matters and delivery?
No. I know that obviously Thames Water have a 5-year programme, but I don't have that. I don't have that level of detail from them that that can be done in that time scale. But obviously, as we've agreed and with the appellant, and we fully accept, this is the separate legislation in place to deal with this.
Okay. Anything further on behalf of the appellant?
No, ma'am. I think, as Ms. Smith has said, we're in agreement with the council's position on this. That this is covered by separate legislation.
Okay, no problem. No problem from my perspective. Then I have taken on board all of the comments. Otherwise, in this form.
Sorry, have you finished with conditions generally at the moment?
Yeah,
I just wanted to. I just wanted to add one matter in that I've been asked to put forward and mute this morning, is that the council would accept, if you were so inclined, to put an earlier timescale on the implementation of this permission to help with the 5-year housing land supply, if this is to be found.
So explain to me what you mean then. So bringing forward the time frame for submission of reserved matters, or bringing forward the time frame for commencement of development following approval of reserved matters, or both?
Both. I think that would be reasonable under the circumstances to consider that, and I appreciate that this is just being opened up at this stage, but I think it would be remiss of me, following a conversation that I've had internally this morning, not to suggest that to you. And it's going to be, it is now a matter that we're raising at other inquiries we have in Vale. We've got a public inquiry in opening next week, as I said, in Drayton, which is also a housing land supply issue, and we are going to be seeking that advanced timescale for that one as well. Admittedly, that's for a very smaller development of about 30 dwellings, but nonetheless, it's now a council requirement that we seek to reduce down the implementation periods for applications where housing land supply is contested.
And what timeframes are you seeking on those particular conditions then?
In those other permissions, we're looking at 18 months, just to reduce it down.
So 18 months for submission of
reserved matters, yeah.
And then commencement following approval of reserved matters?
Sorry, just checking my notes. 2 years.
So that's 2 years as the standard commencement timeframe following approval. That's already in condition 3.
Sorry, yes, no, 18 months for both.
All right. So for submission, you suggest essentially halving the timeframe for submission of reserved matters and commencement 6 months earlier than the 2-year date following
Yes.
approval of reserved matters.
Yes.
In a scenario where, oh no, so you have to submit all your reserved matters applications within 18 months, right? Okay. So let's have some thoughts on behalf of the appellants team, please.
Mum, obviously, obviously we haven't looked at this and discussed this up until this point. I'm just mid-reading a couple of notifications from my client with regards to this. I think in principle, we don't have a particular concern in terms of delivery, but I think I would just want to take instructions from my client on that.
If I can jump in, madam, I mean, frustratingly, we spent 2 hours of our time on Friday afternoon going through these conditions word by word with the council, and this wasn't raised. So there's a theme appearing today, but I suppose I would question what the merit of that is. With, as a house builder, we would always want the flexibility. Who knows what will happen in the next 3 years, and without a sort of policy basis on which to base that, the flexibility is always welcome. We would naturally like to get on and deliver the site, but that has a long established timescales. I think our preference would be to stick with that, as was agreed in the notes that you were sent, and is noted that the council agreed to themselves on Friday afternoon.
Okay, so thinking about Mr. Duval's evidence in his proof of evidence, I think there is an indicative sort of time frame for lead in and start on site from the appellant's team. Can we pick that up so that we can understand what it was that you had in mind about delivery?
How would you like to do that, Madam? Sorry, just
So I'm just trying to go to Mr. Duval's proof, which is I can't give you the CD reference, but I can access it from my internal folder.
Yeah, I'm just also finding it, Ma'am, as well.
So you've even put in there an assumption that the appeal is allowed by September this year, isn't it?
Yeah, that was the first line in the timetable, Ma'am. Yeah.
Do you remember that? I'm just trying to find the paragraph number.
Yeah, it's under the section regarding Nicholas King Homes, which I think might be in chapter 2. I'm also just trying to find my proof as well.
3.21 on page 17.
Thank you.
Well, assuming an appeal decision approval by September 2026, reserve matter submission is by December 2026. So that's just 6 months from now.
I think the important point to note in this, Mum, is not that we won't have the aspiration to submit and then get on site to deliver, but there's two parties involved in any planning application and condition discharge. So with our best endeavours, we can meet certain deadlines, but who quite knows where the determination of a reserve matter submission or condition discharges go, that time can very quickly evaporate. And in a circumstance where the council choose to refuse the reserve matters and we may want to submit an alternative version, etc., those dates can move quite quickly. So ultimately it's your determination of what you consider reasonable. I just reiterate my point that if you decide these timelines, then okay, but the council have already agreed to something else, and flexibility is always considered important for various reasons I've outlined.
Going back to the question I had about the water network upgrades, then, how does that even fit into this sort of anticipated delivery programme? Does anyone know?
No. Mum, to be fair, or not to be fair, because I know it doesn't help the appellants, because we did have a very productive meeting on Friday afternoon, as they've said, but I was given this instruction at 9:30 this morning, and yes, so I'm trying to deal with the fallout of that as well, in terms of how it works in reality, and I appreciate that I've raised it, and perhaps we're too far gone in the process to actually carry this forward, given that we do have the other issues with Thames Water and the infrastructure in that respect.
I'm sorry, we're just reviewing on the side. In the interest of moving it on, if the council wish to stick with this, we'll go with it. So I'll leave that with your judgment, but we've just sort of reviewed collectively between us. Apologies. So yeah, if the council want to go down that route and you are so minded to agree with them, then we'll go with those timescales.
I guess I'm still concerned with is this point about, is it the Grampian condition on the infrastructure upgrades? No development shall be occupied. So foul drainage isn't a pre-commencement condition. It's the network water upgrades. And again, no development shall be occupied. Okay, so it isn't prior to commencement. Sorry, I think I misread that. Okay, noted. I'll take on board those points when I deliberate on conditions further. Anything further on planning conditions?
Ma'am, no, thank you. Not from our perspective.
Okay, great. So let's move on to the Section 106 agreement. First off, can I please introduce Mr. Khan? Thank you for joining us today. I've obviously reviewed the Section 106 in detail, comprehensive as it is. Is there anything that you want to draw my attention to in terms of how it's drafted, or any changes that you've made? Anything that I've questioned about the way that it's put together or its content?
I think the only point from me, Madam, is I believe you helpfully raised, I think it was yesterday, an observation about the figure in the public right-of-way contribution, which was obviously a typo. I'm not sure if the corrected version has found its way to you yet, but that, just to let you know, that sum has been picked up and corrected and now reads £96,300, which is the correct amount.
Yes, that updated version has reached me. I haven't actually reviewed it to check that correction has been made, but I'll obviously take that at face value. I was also made aware about the indexation uplifts and the reason behind the difference between Oxfordshire County Council's compliance statement and the actual content of the Section 106 itself. That is self-explanatory, and I'm content that the compliance statement doesn't need updating on that basis. What we also see, and which I don't think I've raised, is that the education contributions have appeared in the Section 106 as a formula basis, which is obviously the more correct way of doing it.
Yes.
In the consultee responses or in the compliance statement, we've got sort of headline figures, I think, which doesn't necessarily work. So all I'm going to ask then is that you are content that the formula that you've used is sort of tried and tested, has an evidential basis, and it is what has been used to input into the Section 106.
Yeah, I mean they're the county council's formula. Just to be clear, Madam. But yes, I mean we are satisfied that they reflect the standard approach, if you like, to the calculation of the education contributions.
Okay, and the appellant has included in the Section 106 blue pencil clauses if in the event I don't consider any or one of the particular contributions necessary, and I take it that having agreed this with the council and county council, that in fact you are content that these contributions are necessary and appropriate in terms of the development and making it acceptable in planning terms.
Yeah, we've taken that position, Madam. So we're not questioning the basis for any of the contribution sort of basis.
Okay. All right. Is there anything that anyone from the council wants to bring to my attention in terms of the Section 106?
No, if you're content, Ma'am, and you don't have any further questions, then there's nothing else for us to raise.
Okay, that's helpful. Thank you. I am otherwise happy. I've had an opportunity to review it, and I've obviously made my questions known in writing. I will say that going forward, though, the PINS guidance has been updated, and I think the sort of final versions of Section 106s will be expected 10 working days before the opening of an inquiry in future. So we're going to have to get our skates on for future inquiries. But no, helpfully this one was comprehensive, and I'm glad that you've reached a largely agreed position throughout its drafting before presenting it to me. So no big issues otherwise. I'm content to wrap up the discussion on section 106 as well. The only question that is outstanding is what date you'll be submitting
Yes.
the finally engrossed version by, please.
When you say finally engrossed, you presumably mean the signed and sealed version, do you? The completed
Yes.
version. Yeah. So we've got 4 parties. Thankfully, no mortgagee, which always tends to add a week or two to proceedings. So, subject to the thoughts of obviously the council clients, I would have thought 2 weeks would be a reasonable period to secure completion.
Okay, so I'll put the 14th of July then. Is that okay?
Yeah, thank you, madam.
No problem. All right. Is it okay now if we take a 15-minute adjournment so I can get a glass of water? I forgot to bring one to my desk, and I'll just tidy up a few papers on my desk before we come back to the matter on the evidence on housing land supply from the council and closings. So adjourning now and resuming at 11:05. 11:05. Wonderful, thank you. Thanks all. 11:05, welcome back. Thank you for returning promptly. So we're going to resume the inquiry to hear the closings. And before we do that, we're just going to quickly return to the point about the documents submitted by the council on the housing land supply point. I've got some thoughts about how I'm going to deal with it, but is there anything that either party wishes to say before I make a ruling on it?
Madam, Mr. White asked me to explain the chronology of how that document was received, and over the period of conditions being dealt with and that short adjournment that we've had, Ms. Smith has been able to speak to the policy team and has provided me with instructions. Can I give that information to the inquiry? I think it's right that I do so.
Of course, yes, please do.
Can I just check that Ms. Smith can hear everything, because on my screen it says that she's on hold, and I just want to check that she's there. I'm just texting her, madam.
No
Sorry.
problem. That's fine. I'm content to wait. Well, no problem.
Madam, I'm sorry. She's read my text. I think maybe I'll update you anyway and make a note of the ruling, and then perhaps before closings are delivered, we can make. Oh, it seems that she's in.
Ah, yes. Yeah, I can see the change
Right.
there.
Sorry, I'm so sorry. I didn't notice what was going on. Sorry, my window changed.
No, just glad you're there. Thank you, Ms. Smith. The pro forma that was sent to you yesterday, I'm instructed, was received by the policy team on the 6th of May. No pro formas that were received have been looked at because the policy team is currently stretched dealing with JLP hearings next week and JLP2. They will not be looking at any pro formas until after the JLP hearings have concluded next week. Ms. Reid, as a witness in 2 appeals in relation to the Scott schedule in the 2nd appeal, the one that you've heard about, madam, the Drayton appeal, emailed the policy team on the 17th of June regarding the Scott schedule in that appeal. The policy team noted that a further reply had come in on the site with which we are talking about and sent it to her cold. Those are the words that are used, cold. They did not know what was in it. They simply sent it to her knowing that it was an update. She then analysed what was in it, and the rest you know. And again, despite her emailing them on the 17th of June, they emailed her and she got it on Friday, as you already know.
And sorry, Mom, Helen doesn't work on a Friday to compound matters. So she was looking light touch for emails.
That's what happened.
Mr. White, is there anything further that you need to know?
Not that I need to know, I don't think, ma'am, but I do wish to make a submission that in my submission, that's absolutely categoric that you should not accept it, because the fact that it's been accepted that the LPA have had it since the 6th of May, frankly, it's not a matter for us, the appellants, or you, as to the internal processes, but the council had that information, you're now told, prior to exchange of evidence. And it was, frankly, it's incumbent upon parties to put in their evidence in accordance with the timetable, the evidence they seek to rely on at an appeal, unless there's very good reason why that hasn't happened. So you now know that that pro forma was received well in advance on the 6th of May. The fact it was asked for by Miss Reid on the 17th, frankly, she could have asked for it before, or frankly, being a bit more severe, it was incumbent upon her to ask for that information before the 17th of June. So its late production is completely as a result of the LPA and the processors and their witness, frankly, not putting in place arrangements to ensure it was in evidence. So in those circumstances, I really do think that it's fair and reasonable for you not to accept it in the light of the fact that the council have had that piece of evidence for 7-8 weeks prior to its production yesterday evening or late afternoon. So that's the position of the appellant. Thank you.
Okay. I hear you both, and it's difficult, but I think given that this is given my current thinking on the case, it would be useful for me to accept the evidence and for the appellant to provide its response in writing following the close of the inquiry. Mr. White, I regret that will necessitate further work on your part and that of the rest of your team, or some of your team at least, but that is my ultimate decision.
Yes, well, in the light of that, ma'am, as I said, I'm currently instructed, unless by the time we close, I would like till Friday. Mr. Neame tells me he has other arrangements, like he's got a hearing on Thursday. He's got to travel to that hearing on Wednesday. That's why we asked for the Friday. So could we put a written response by Friday?
Yes, you may. Close of business Friday will be the deadline for your final comments, if that's okay.
Yes,
And
and we sorry.
No, that's fine. And I was just sort of thinking, going through the inquiry document references, can you please also both submit your closings electronically to me? And then we'd obviously then have final comments by Friday, close of business, your costs application Monday, close of business, the council's cost response by, the Thursday close of business, and then again, the following Monday close of business will be for your final cost comments.
Madam, I'm so sorry to ask this, but could I have a slight extension on the response? The reason is that next week I'm in the JLP hearings, but on Wednesday I have to leave Oxfordshire and be in the High Court in London and then go back to the JLP hearings. It's just a logistical nightmare. I can't even get my head around at the moment as to how I'm going to do it. And so to add a cost response to the Thursday, I'll do it if I have to. But I'm making a plea to please ask for Monday, and I'll do it over the weekend.
Okay, so that would be Monday the 13th of July.
Yes.
Okay, given that the Section 106 may not appear until around the 14th, I can deal with that. Mr. White, what would you like in terms of a time frame for submission of the final cost comments around that time?
Ma'am, I don't need more than 24 hours, frankly.
Okay, so we'll stick with close of business 14th of July. Is that okay?
Yeah.
Thank you. Okay, can everything be sent through the case officer in the usual manner?
Mum, could I just, the final matter on this, because it will go directly to the cost.
Mhm.
Could my learned friend just put in writing, and she can do this whilst I'm speaking, as she doesn't have a right to reply, but could she just send to Pins or those that instruct her, just the chronology she outlined orally of when that was received, because obviously that's material for the costs application. So just that you, when you're determining the costs, and me, when I'm writing the cost application, understand the exact chronology that the council say in relation to this matter. I obviously have a note, but I want it to be 100% accurate. So could I just ask that they formally confirm what was said orally in a note to you about the dates of receipt of the pro forma?
I did see Ms Lambert shake her head. Is that correct? Are you
Yeah.
happy to do that? Yeah.
Thank you.
Okay.
Thank you very much.
Thank you. Yes, it's just become far clearer to me that I've also given myself the additional work of a cost application to deal with.
Well, to be fair to you, you haven't. The appellants have, but we would obviously say it was beyond our control. But you're right. Unfortunately, that is an unforeseen consequence.
Never mind. Anyway, we are where we are. Let's do formal closings, please. So as and when you're ready, Ms Lambert, please.
Mum, can I just, before we get there, can I just ask, as I'm going to be working on my closing while my learning friend is delivering her, could I ask for two things? Would you mind if I turn my camera off, because it's much easier to type if one's not on screen? And secondly, could I just have 10 minutes at the end of her closing just to send you my final version, which has my comments added to it, so it saves your pen when I'm delivering my closing?
That's fine by me. Both are fine by me. Ms Lambert, do you have any objections to that?
No, of course not. And Madam, just to let you know, I've sent my closings to Mr White electronically, and Tracy Smith, I hope, has sent them to your case officer.
Thank you. I'll receive them in due course. Thank you.
Are you happy for me to start, even though you don't have them yet? Very well. Thank you, Madam. These are the closing submissions on behalf of the council. This is a major suburban mass housing development inappropriately proposed on unallocated open countryside outside of the settlement of Kingston Bagpuys with Southmoor, KBS. The main issues identified by you are set out at paragraph 2. Before turning to the main issues, some preliminary points in relation to the development plan and material considerations and the lawful approach for the decision maker are addressed. Firstly, the statutory development plan and the weight to policies. The National Planning Policy Framework is only guidance. The presumption in favour of the development plan still exists as a matter of law. Vale of White Horse District Council does not accept that it cannot demonstrate a 5-year housing land supply. However, the matter of engaging the tilted balance does not end there. Even if there is no 5-year housing land supply, there is still a question of weight and an exercise to be undertaken under paragraph 232 NPPF. That is because there is no such thing as an out-of-date development plan, despite the repeated assertions in Mr Duval's proof of evidence. And the starting point by virtue of section 38(6) of the Planning and Compulsory Purchase Act is the development plan. That does not change whether or not the tilted balance is engaged. The proper interpretation of planning policy is ultimately a matter of law for the court. Policy statements should be interpreted objectively in accordance with the language used, read in its proper context. There has been no assertion that the Council's policies are not consistent with NPPF. Overall, the careful analysis of weight to policies undertaken by Ms O'Neill, not challenged, at paragraph 9.8 to 9.16, is commended to the inquiry. Indeed, that exercise also deals with weight to policies in the event of lack of a 5-year housing land supply. The appellant has instead relied on age and on the fact that the Reg 10A review sets out that the housing requirement needs updating. As Ms O'Neill told the inquiry, it is really important that age alone does not determine weight. Relevant considerations include consistency, effectiveness, whether the strategy is delivering and continuing to be implemented, and the inspector examining part 2 found the strategy sound in June 2019, which is relatively recent in plan-making terms. The appellant has not engaged in the consequences of the housing requirement needing updating. The housing requirement is currently higher than local housing need. During the Reg 10A review, the housing requirement was higher than the standard method at the time. This is not a case of a low housing requirement stifling growth, and therefore the appellant's mantra that the requirement is out of date is a moot point that goes nowhere. The appellant also fails to engage with the fact that CP3 was rated amber, CP4 was only rated red in relation to the housing requirement, and the strategy was rated green and CP8 was rated amber. Mr de Val betrayed the appellant's position on this when he said that the Reg 10A review result was black and white. It is not. The appellant's approach is simple and blinkered and has failed to grapple with the real-world relationship between the housing requirement, which is actually seeking to deliver higher housing than the current LHN. The policies are consistent or recently adopted, and any development plan conflict is serious. Whether the council has a 5-year housing land supply. The council's position is that it has a housing land supply of 5.34 years. A number of matters are agreed between the main parties, and I summarise them as the period of assessment, the requirement, the buffer, and the total requirement. The divergence between the parties therefore crystallises into 2 issues. Firstly, whether 7 Category B sites should be properly regarded as deliverable within the 5-year period, and secondly, whether the council's approach to windfall development should be accepted. Looking at the legal and policy context, by paragraph 78 NPPF, local planning authorities should identify and update annually a supply of specific deliverable sites sufficient to provide a minimum of 5 years' worth of housing against the housing requirements set out in adopted strategic policies, and Annex 2 defines deliverable as a realistic prospect that housing will be delivered on the site within 5 years. It is submitted that the appellant has challenged the council's evidence of a 5-year supply as if the standard of proof was that the decision maker must be sure or certain, or that it is probable that sites would deliver. Whilst there has been a change in the definition of deliverable in NPPF, the phrase realistic prospect has not changed, and there is authority for the meaning from the St Modwen case both at first instance and Court of Appeal. The proper approach to deliverability is beyond doubt, and the council has clearly and transparently set out that this is the approach taken in its latest housing land supply statement. The following points can be summarised from the Court of Appeal judgment. Firstly, there is a distinction between deliverability and delivery. Secondly, the fact that a particular site may be capable of delivery within 5 years does not necessarily mean it will be. Thirdly, LPAs do not control the housing market, and there may be reasons why a site is held back, such as financial or commercial. Fourthly, sites may be properly included in 5-year housing land supply if the likelihood of housing being delivered within the 5-year period is no greater than a realistic prospect. And fifthly, to be deliverable does not mean certain or probable that housing will in fact be delivered upon it or delivered in its fullest extent possible within 5 years. This approach was affirmed in the case of East Bergholt, which emphasised the importance of planning judgments in this area. The appellant's evidence appears to require certainty, but without justification. The position in Vale is not one which demands a higher test, and the context of the Vale housing land supply is set out below. Housing is needed, boosting the supply of housing is noted. The development plan does this. Local government reorganisation does not affect delivery of housing, as it does not affect developers. Therefore, in these circumstances, there is no need to look for certainty or probability in assessing deliverability. A realistic prospect is all that is needed. Approach. The difference between the parties as to the level of deliverable supply is a difference of 1,101 dwellings. Whilst the council maintains a supply of over 5 years, the appellant calculates it at 4.24 years. There are no decision letters before this inquiry where decision makers have concluded that the council does not have a 5-year housing land supply, and the argument advanced is unduly pessimistic. The clear evidence referred to in NPPF in the context of deliverability must accordingly be understood in the context relevant to Vale, and the matter approached with common sense and judgment. For the reasons set out above, it is not correct to seek certainty or some kind of evidence which demonstrates a guarantee that a site will deliver. The non-exhaustive list in the MPPG, para 007, includes current planning status, firm progress being made towards the submission of an application, firm progress with site assessment work, or clear relevant information about site viability, ownership constraints, or infrastructure provision. Mr. Neame does not state that the pro formas are in any way excluded from the above non-exhaustive list. In the Council's most recent housing land supply statement, they plainly fall within the second bullet point, a written agreement between the local planning authority and the site developer, which confirms the developer's delivery intentions and anticipated start and build-out rates. Nature of the evidence that exists before this inquiry. The The process used by the council is set out in full by Ms Reid at section 6.2 of her proof. She states, "I would like to highlight the extensive work that goes into Vale's 5-year housing land supply analysis. It is a very comprehensive report that contains detailed evidence on each site, along with detailed analysis of average lead-in times and build-out rates across the district by type and size." And she concludes it is a very rigorous and evidence-led process to assess the deliverability of housing sites, and states it is robust. This is a third-party independent endorsement of the council's process. Windfalls. The council makes an allowance for 180 dwellings per annum from windfall sites. This is supported by detailed evidence presented in the 5-year housing land supply statement and results in 360 units being added to the 5-year housing land supply in years 4 and 5. NPPF Para 75 provides that where an allowance is to be made for windfall sites as part of anticipated supply, there should be compelling evidence that they will provide a reliable source of supply. Any allowance should be realistic, having regard to the strategic housing land availability assessment, historic windfall delivery rates, and expected future trends. The word realistic is therefore highly relevant. Whilst compelling evidence is required, Para 75 essentially tells what this is and requires no more than having regard to the past and expected future. It is submitted that past historic trends are more robust as they are evidence of what has happened as opposed to what might or might not happen. As the inquiry was told, there is no need to import national trends to this specific area of Oxfordshire where delivery is strong. The council has actually undertaken an unusually thorough approach with regard to windfalls. It has assessed historic windfall delivery rates, previous land uses, the status of the development plan, whether the windfall was major or minor in nature, and whether the site was brownfield or greenfield land. This has been done for a data set spanning 2011 to 12 onwards, which means that it includes a full range of market conditions and policy contexts, including unexpected economic events such as Brexit and COVID. There are a number of filters applied in order to refine the windfall allowance. Furthermore, the windfall allowance is only applied to years 4 and 5 and not to years 1 to 3 to avoid any double counting. As Ms Reid explained to the inquiry, actual net windfall completions have averaged 574 dwellings per annum. It is nonsensical to attempt to rely on wording regarding future trends when the council has taken an incredibly cautious approach to windfall allowance, such that it is unclear how future trends could filter or refine this windfall allowance any further. The council commends its approach of adding 360 units to the supply. In relation to the 7 sites in issue, the extensive evidence is set out in the evidence of Ms Reid. Reliance is placed on all such evidence, much of which is not repeated here. Some summary points by way of submission are set out in Appendix 1 to these closing submissions. The approach of the appellant in relation to the site assessment was flawed for the reasons already addressed. Conclusions on housing land supply. It is plain that if the correct tests are applied and the quality of the evidence is appreciated, the council can demonstrate a 5-year supply of housing land. Consequences if there is no 5-year housing land supply. If, contrary to the council's extensive assessment, the decision maker finds that the council does not have a 5-year housing land supply, then it is submitted that any shortfall is nothing like the order suggested by the appellant. From a number of authorities, including Hallam Land, if one of the objectives of the NPPF is to boost the supply of housing, then it is relevant that the decision maker should consider the scale of any shortfall and the steps being taken to address it. The scale of the shortfall. If there is a shortfall, it is not significant even on the appellant's case. The appellant's witnesses misunderstand the relevance of this. Of course, it still means the tilted balance is engaged, but scale of shortfall goes to weight policies. In the Hearts Lane decision letter, the housing land supply put forward by the respective parties was 2.46 to 2.76 years. In the Southminster appeal, it was 2.7 years. In the Thacombe appeal, the housing land supply was 2.9 years. The appellant has put forward the worst case scenario, which is a limited shortfall of 0.76 years. It is also important to understand the context of any shortfall. Policy CP4A of the Local Plan Part 1 updated the housing requirement to include Oxford's unmet needs and set out the overall housing requirement as 22,760 homes over the plan period to 2031, including 2,200 dwellings for Oxford City. The reason for this inflated and uplifted requirement was because the council entered into the Oxfordshire Growth Deal. This was considered by all as ambitious housing growth by 2031. From the adoption of LPP1 and LPP2, it is evident that the Council has had a serious commitment to boosting housing supply in the district, planning for homes to meet its own need and the needs of its neighbour, and adopted on the basis that it had identified allocations to meet those needs. That is evidenced by the fact that the development plan requirement is higher than current LHN. When annualised to 1,138 per year, including Oxford's unmet needs, or 1028 excluding Oxford's unmet needs, which is still higher than current LHN. This context is highly relevant. It shows an engaged and proactive council. Turning to the actions of the local planning authority, the council has a post-NPPF adopted local plan, which has identified sufficient land to exceed its own needs and needs of others in full. That represents the best of steps any authority can take to address housing land supply, particularly when the housing requirement has not been suppressing housing. The council does not build houses and it cannot force developers to develop. The council is doing everything it can at its end to improve housing supply, and it should not be punished for seeking ambitious growth levels, taking on a significant proportion of a neighbouring authority's unmet need, and for having a recently adopted local plan such that its spatial strategy is dismissed. This council has been proactive in ensuring it has an up-to-date plan. On the 5th anniversary of LPP2, the council already had an emerging plan in the wings. Before the council even knew that there might be changes to the standard method and NPPF, it had already begun preparing the JLP. Local plan preparation needs a huge input of resources, both financial and human. The national picture in relation to local plans is poor. Vale of Whitehorse, as an authority with dedicated staff, has sought to ensure that it has a plan. Such positive action can be taken into account in assessing weight to policies in light of the lack of a 5-year housing land supply, and that position is different to the position of other local planning authorities in the decision letters before this inquiry. In terms of the Council's emerging joint local plan, due to the timing of its submission, the transitional arrangements in relation to calculation of housing need apply. As with LPP1 and LPP2, the JLP looks to oversupply in relation to the minimum requirement at the time it was submitted. Again, Vale has looked not just to meet minimum needs. For the next 10 years, the requirement is 816 per year, which is higher than the standard method number at that time. Looking at sources of supply and emerging policy HOU2, these total 19,779. So there is a buffer of over 5,000, and annualised is almost 988 dwellings per year of supply. Again, that is higher than current LHN. Whatever the outcome of the progress of the JLP, there will not be sterilisation of strategic development. The emerging JLP allocations are carried forward from LPP1 and LPP2, so any uncertainty with the plan-making process does not translate to uncertainty with allocations and supply. The allocations already exist, so there is no housing supply vacuum whilst the JLP examination proceeds. Furthermore, the Council has already committed to JLP2, and Ms O'Neill told the inquiry that the Council has resourced a team to progress that in accordance with the government's timetable. Given the tight timetable for local plans going forward, JLP2 will be adopted by 2029, well before LPP1 and LPP2 expires. Therefore, any contentions that there will be a shortfall towards the end of the plan period are entirely misconceived and nothing more than a red herring in this inquiry. This is not an authority relying upon an obsolete or abandoned strategy. Since the adoption of LPP1, the Council has undertaken the statutory Reg 10A reviews, prepared and adopted LPP2, submitted a replacement joint local plan for examination, and already begun work on the subsequent review. The evidence demonstrates a planning authority actively reviewing and implementing its spatial strategy rather than relying upon an outdated policy framework. Those matters reinforce rather than diminish the substantial weight that should continue to be afforded to the adopted spatial strategy. Other measures of boosting the supply of housing. Success in boosting the supply of housing is not only measured by 5-year housing land supply. This council has had enormous success at actually seeing houses built in its district. Table 1 in the council's HLS rebuttal identifies that since 2015, the council has delivered on average 1,317 homes per annum in the last 10 years. There have been over 15,000 homes built since 2011. And contrary to the interruption during the cross-examination of Mr. Duval, Table 1 does include Oxford's unmet needs at the point LPP2 was adopted. Table 2 outlines the constant changing and moving target the council has delivered against. Table 3 shows the extraordinary housing delivery test results since its introduction in 2018. Over the plan period, it has delivered thousands of homes ready to be occupied. That is factual, whereas 5-year housing land supply relies on judgment. Conclusion on consequences. If the tilted balance is engaged, weight to policy still needs consideration in the context of scale of shortfall, a reasonable housing land supply, the context of the housing land supply, successful completions, and positive action to produce plans. These are all relevant considerations to be taken into account. No such exercise has been undertaken on behalf of the appellant. Rather, a mantra was consistently delivered about how the lack of a 5-year housing land supply meant that the development plan is out of date, and there was limited conflict with policies, which made no sense. The acceptability of the site for the proposed development in light of the development plan and national plan policy. In relation to the correct approach to construing policies, the Council submits the decision maker must seek to discern from the language used in formulating the plan the sensible meaning of the policies in question in their full context and thus their true effect. The context includes the objectives to which the policies are directed, other relevant policies in the plan and the relevant supporting text. And thirdly, the creation of development plan policy by a local planning authority is not an end in itself, but a means to the end of coherent and reasonably predictable decision making in the public interest. It is also important to note that the appellant does not suggest that the development plan should be considered out of date, other than by virtue of the 5-year trigger. Conflict with up-to-date policy is, in NPPF terms, an adverse impact and should normally mean that permission is refused. In this case, the development plan was made in the context of NPPF, had fully taken into account the objective of significantly boosting the supply of housing, the importance of affordable housing, and the various factors that inform sustainable development. It is the expression of a plan which was shaped by local people. As a result, it is submitted that decision makers should take the development plan to therefore set out the appropriate spatial strategy for Vale of Whitehorse that has taken into account reasonable alternatives, including the site as part of the sustainability appraisal for LPP2, and which has been considered to be effective over the plan period to 2031. The spatial strategy. Policies CP3 and CP4 provide an overall strategy and must be considered in the context of other relevant policy. The strategy of the plan is not just about housing, it is about employment land, economic growth and housing growth, and co-locating housing, jobs, services and infrastructure. The overview sets out 3 main strands to the strategy, and the first bullet point is to focus sustainable growth within the Science Vale area. Figure 4.1 sets out the ambition for promoting Science Vale as a world-class location for science and technology-based enterprise and innovation, especially the enterprise zone sites at Milton Park and Harwell campus, sites in Vale. Paragraph 4.16 of LPP1 sets out that Science Vale is one of 3 growth areas in the Oxfordshire knowledge spine, with significant potential to build on the extensive existing research infrastructure and the designated enterprise zone, and the strategy of the local economic partnership includes supporting economic growth to ensure the potential of this important area is maximised. Paragraph 4.17 sets out that 70% of the 23,000 new jobs forecast for the district to 2031 are likely to be located in the Science Vale area, and the jobs being created in Science Vale generates a need for a significant proportion of houses required in the district. Crucially, paragraph 4.18 informs that 75% of the strategic housing growth is allocated within close proximity to these key Science Vale business locations, with new infrastructure to enable growth potential to be realised. It is also important to note the recent confidence the government has shown in the Science Vale. Only a year ago did the government issue a press release regarding the next phase for rolling out AI growth zones, noting that the first of the hotbeds of AI development would be in Culham to unlock fresh investment and new jobs as the government delivers on its plan for change, and setting out that AI growth zones will revitalise local communities by attracting billions in private investment, sparking fresh jobs at the cutting edge of AI, while also securing Britain's position as a global leader in the technology, all to be secured with streamlined planning approvals, fast-tracking the rollout of critical infrastructure from data centres to high-capacity energy connections. The Minister for AI said that the growth zones will transform areas across the UK into engines of growth and opportunity, unlocking new jobs and revitalising communities across the UK and securing the UK's place as a world leader in this vital technology. The strategy is to build on the success of Science Vale, to push it further for further growth, and to co-locate homes, jobs, transport and infrastructure to support growth in an internationally important area. The strategy is not bolt-on development in the countryside on the edge of a larger village. KBS is not well located to those areas selected for their success and for continued vital growth, and Mr. Duval was spectacularly unable to explain how anyone would travel from KBS to any of the Science Vale sites. Even the attempt to say that they could change buses in Oxford was wholly unsupported by information. With local input, the council has determined where to focus jobs, homes and infrastructure, and that strategy is nationally and internationally successful. That is what the public expect from the strategy, and the strategy should provide for predictable decision making. Adding homes on the edge of KBS is not consistent with the strategy that is planned and which local people want and accept. This is all consistent with the Oxford Growth Commission interim report, a report relied upon by Mr. Duval in his proof of evidence, which notes the history of growth in Oxfordshire and the potential for further transformational economic growth. It advises that a new strategic vision requires a strategy joining up economic growth with new housing and aligning economic growth with new housing to improve affordability and reduce commuting pressures. That is a strategy already employed by Vale. It says that the strategy for economic growth should include a focus on urban, edge of city developments and urban extensions, and this includes high quality mixed use development of housing, and that encouraging development in these sustainable locations will support agglomeration and innovation and relieve pressures on more rural locations. It has identified 13 opportunity areas for housing and jobs to support the economic growth potential. KBS is not identified. It is not identified because, contrary to the unsubstantiated contention of the appellant, housing at KBS will not support the strategy for economic growth that is important on a county level, nationally and internationally. And this strategy of focus in the Science Vale is taken forward in the JLP, and I quote from Policy SP1. The overview of LPP1 also sets out a vision in the second bullet point to reinforce the service centre roles of the main settlements, and the final bullet point to promote thriving villages and rural communities while safeguarding the countryside and village character. Figure 4.1 sets out how this will be done by allocating strategic housing growth to larger villages, including this one. Ultimately, Mr. Duval's evidence was reduced to the proposition that because KBS is a sustainable settlement and because the proposal is capable of being made technically acceptable, planning permission should follow. That is not what the development plan provides. The purpose of the plan making process is not simply to identify settlements capable of accommodating growth. It is to determine where strategic growth should occur following sustainability appraisal, evidence gathering, public consultation and independent examination. Mr. Duval's evidence does not explain why that strategic judgment should now be displaced in favour of this unallocated site. Core Policy 3. This policy sets out the settlement hierarchy, which is the order of preference for where development should go. Larger villages are not the most sustainable location. Under the subtitle Larger Villages within the policy box for CP3, it is clear that unallocated development will be limited to providing for local needs and to support employment, services and facilities within local communities. Therefore, in order for unallocated development to be permitted, it should be demonstrated it provides for local needs and supports employment, services and facilities. There is no evidence that the proposals meet local needs in KBS. There is no evidence that it is needed to support employment, services and facilities. Mr. Duval said the proposals provide employment. The proposals will provide some temporary employment. See economic benefits for further detail. There are no permanent jobs provided. He said the proposals will support the school. There is no evidence that the primary school might close due to low numbers. He said new residents would support facilities. There is no evidence of shops or pubs closing due to low patronage. The appellant has not even attempted to properly justify the proposals against Core Policy 3. Contrary to the written evidence of Mr. Duval, supporting text to Core Policy 3 does not provide the test by which this appeal should be determined. Attempting to pray in aid figure 4.1, which in any event supports the council's case, does not assist as it is not part of Core Policy 3. There is conflict with Core Policy 3. Core Policy 4, Mr. Duval accepted that the site is not in the built area of KBS, and he accepted that the site is not allocated. Policy 4 is clear that development outside of the existing built area of settlements will not be permitted unless allocated. The wording of Core Policy 4 in the appellant's opening submissions is mistaken, and there are no caveats for larger villages in Core Policy 4. Attempting to use a housing supply table to justify unallocated windfall development, which amounted to 4% of supply, not 5% as suggested, in cross-examination of Ms. O'Neill was misconceived. Ms O'Neill was not moved to accept that the appeal proposal complied with Core Policy 4 as a result of a housing supply table. She was right, because the table is clearly for information purposes and is prefaced with the words "the contribution of all sources of housing supply are shown by the following table." Furthermore, the housing requirement is easily met without windfalls according to the table. And lastly, LPP1's own definition of what constitutes a windfall site would not include the appeal site, and nor does supporting text at para 412, which requires windfalls to be in accordance with the policies set out in the local plan. As Ms O'Neill stated in cross-examination, windfalls should be within settlements. Core Policy 4A provides for further allocations in addition to those in Core Policy 4. It does not allow for unallocated development. Core Policy 8 does not allocate the site despite allocations at KBS, and therefore the proposals conflict with this policy. And Core Policy 8A contains additional allocations for the sub-area, and despite allocating a site at KBS does not allocate the appeal site. The proposals conflict with this policy. Core Policy 43 encourages developers to make provision for the effective use of natural resources, including avoiding the development of the best and most versatile agricultural land, unless it is demonstrated to be the most sustainable choice from reasonable alternatives, by first using areas of poorer quality land in preference to that of a higher quality. There has been no assessment of reasonable alternatives by the appellant, and this policy is breached despite not constituting a reason for refusal. Mr Duval accepted that there was therefore conflict with CP3, CP4, CP4A, CP8, CP8A, and CP43. Is conflict with the policies limited? There is no partial compliance with any of these breach policies, and there is no room for Mr Duval's conclusion of limited conflict or minor conflict. Does conflict with the policies mean there is conflict with the development plan? The appellant's approach has been to list every relevant policy, including some dealing with reserved matters, and set out whether there is compliance and then do a mathematical exercise in order to demonstrate compliance with the development plan as a whole. As Ms O'Neill told the inquiry, assessing whether there is compliance or conflict with the development plan as a whole is not an arithmetic exercise. From Corbett and Cornwall, it is a matter of planning judgment, and matters to take into account include how firmly a policy supports or conflicts with the proposed development, the relative importance of the policy to the plan's overall objectives, and the extent of breach of policy. There has been no such assessment or equivalent assessment by the appellant. Ms O'Neill has explained in detail why conflict with the most important policies for determining the appeal results in conflict with the development plan when read as a whole. She told the inquiry these policies go to the heart of the development plan, and states that this is not a matter of weighing the number of policies with which a proposal complies against those with which it conflicts, as some policies are of greater importance than others. And in this case, the conflict with CP4, which is the principal policy governing the location of new housing development, is reinforced by the conflict with the wider spatial strategy established by CP3 and CP8. And having regard to the fact that these are key spatial policies of the development plan, I conclude that the proposal conflicts with the development plan when read as a whole. Her evidence properly considers the relative importance of the policies to the plan's overall objectives and the extent of conflict, and her approach is commended to the inquiry. This is supported by the fact that when it comes to plan making, the first step NPPF advises is that the development plan must include strategic policies, which should set out an overall strategy for the pattern, scale and design quality of places. The strategy, as agreed by Mr Duval in cross-examination, is the thread running through the plan and is crucial to the shape of the plan. Furthermore, it is supported by the recent Spring Hill Farm decision letter, which relates to a site closer to the settlement of KBS than the appeal site, and in which the inspector concluded that conflict with the council's spatial policies is conflict with the development plan as a whole. Conclusions on spatial strategy and delivery of housing. In summary, the development plan plainly indicates where development will and will not go. The fact that there have been allocations and growth in KBS does not support further unrestricted growth on unallocated land. What that growth demonstrates is that the key strategic decisions about growth of the village have already been made through the development plan process. The development plan directs locations for development with the obvious purpose of providing for sustainable development in a district with a real prospect of exciting economic growth. Reading CP3, 4, 8, 4A and 8A together, it is plain that the appeal proposal in its totality conflicts with the development plan spatial strategy, and given what that strategy seeks to do, to identify land to meet the council's local housing need and meet the needs of a neighbouring authority over the plan period and focus economic and housing growth in Science Vale, and that it was post NPPF, that is conflict which attracts significant weight with or without a 5-year housing land supply. The principal adverse impact identified by the Council is not a technical objection. It is the conflict with the adopted spatial strategy itself. The resolution of highways and other technical matters does not diminish that conflict. The local plan has already directed substantial housing growth to KBS through the allocation to the east of the settlement following sustainability appraisal, extensive evidence gathering and independent examination. Granting permission for a further major unallocated expansion in a different location, absent any compelling change in circumstances requiring such departure, inevitably diminishes the significance of that strategic exercise. The conflict is therefore not merely technical, it goes to the integrity of the plan-led system itself. Turning to the benefits. Housing. The Council accepts that there is a need for housing and considers this benefit to attract moderate weight, increasing to moderate significant if there is no 5-year housing land supply. It does not agree with substantial weight given that the Council continues to identify land to meet its housing needs through the JLP and that those strategic sites focused in the most sustainable locations are already in the pipeline through LPP 1 and 2. The Council also relies on its strong delivery history. There are various examples of decision letters where very substantial weight has not been applied to market housing. The Council also accepts that there is a need for affordable housing, and this is afforded significant weight. However, the affordable housing being provided is policy compliant, and giving policy compliant affordable housing the maximum level of weight leaves no room to incentivise developers to offer more than policy compliant affordable housing. There are examples of decision letters before the inquiry where the same weighting has been applied in similar affordable housing need contexts. Housing is not unique. It will come forward on planned development. This housing is as mainstream as it comes. No older persons housing, no self-built housing, policy compliant affordable housing, and no other uses other than C3 despite a community use shown on the master plan. Economic. The weight to economic benefits is not agreed, and the basis for the appellant's weighting is flawed. Despite criticising Ms O'Neill for not applying significant weight to economic benefits pursuant to Para 85 NPPF, Mr Duval was aware of the Bewley Homes case cited by Ms O'Neill and conceded that significant weight was not always his starting point. This was confusing given his criticism of Ms O'Neill's conclusion and more confusing given the number of inspected decision letters where less than significant weight has been applied. Mr Duval relied upon the HBF housing calculator informed by the Litchfield's publication at CDLO2. On examination, this revealed that the employment to be generated by the development was calculated to include direct, indirect and induced employment. The figure of 865 jobs relied upon by the appellant is therefore wildly inflated, and there is no figure the appellant can provide for direct employment. Mr Duval also accepted all jobs generated would be temporary to construction. His planning balance assessment included that this would provide local labour, local apprenticeships or local training schemes, but there is no obligation that any such schemes will be provided or that any employment will be sourced locally. He listed tax revenue and council tax revenue as part of the economic benefits. There was no breakdown of what the tax revenue was or how this was calculated. Council tax is simply paying for services and is not revenue generating for local authorities. The PPG makes clear how local finance considerations should be assessed, and appeal decisions demonstrate how other inspectors have concluded that tax receipts are not economic benefits. The economic benefits have been exaggerated. In summary, nothing here is unique. It will all come forward on planned development. Environmental. The biodiversity net gain is a requirement and the modest over provision does not elevate this benefit, and other appeal decisions are consistent with this approach. Other. The location of the development is as sustainable is not a benefit. All development should be in a sustainable location, that is neutral. Local infrastructure delivery is supported by virtue of Section 106 contributions, but these are required to mitigate the impacts of development and are neutral in the planning balance. The planning balance. The appellant has undertaken the planning balance on the false premise that the proposal complies with the development plan. Applying the approach from Para 45 of Monkhill, Section 38.6 applies throughout, and the proposal does not comply with the development plan, and Para 11C does not apply. Para 11D applies if there is a lack of 5-year housing land supply, but the policies are not out of date for any other reason. The application of Para 11D2 requires particular regard to key policies for sustainable locations. This is agreed. Making effective use of land, not agreed due to loss of BMV, and providing affordable homes. This is acknowledged. Section 38.6 is still engaged, and an assessment assessment of weight to policies is required. The proposal is in conflict with several development plan policies relating in particular to harm to the spatial strategy and loss of BMV. Overall conflict is significant even without a 5-year housing land supply, and given the policy's breach, this represents conflict with the development plan as a whole. The Council's position is that the housing land supply situation in the district is complex. There is an ambitious requirement in policy, which has not stifled supply compared to local housing need, and completions are strong, supply is strong, and the strategy is sound. There is no need to significantly reduce weight to policies. The main benefits include housing and policy compliant affordable housing, which are afforded moderate weight and significant weight. However, the mainstream benefits cannot overcome the permanent harm to the spatial strategy of the development plan, in which local people have confidence, and which Mr. Duval has failed to include as a harm in the planning balance. And the adverse impacts include loss of BMV, and as Ms O'Neill told the inquiry in examination in chief, landscape impact has evidence in the landscape consultation responses and the LBIA. Whether on the flat balance or tilted balance, planning permission ought to be refused. To conclude, the development plan does not allocate the site or allow for development at the site. The NPPF states the planning system should be genuinely plan-led. Allowing this appeal flies in the face of that. Such permanent harms to deliver 249 homes cannot be justified. But more than that, development on sites like this make a farce of the local plan process that the government advocates and which local people trust. This is a strategy which has delivered thousands of homes, co-located with employment land in sustainable locations, in areas attracting national and international investment. This is not a site the council or the parish council accept should be developed, and the local plan and the emerging JLP reflect that. Ultimately, this appeal is not really about whether KBS should grow. The development plan has already answered that question, nor is it about whether the proposal can be made technically acceptable. The council accepts it can, nor is it about whether benefits would arise. Some plainly would. The real question is whether a further major expansion should now be permitted in a location that the development plan considered but did not select, and in light of strong supply and completions. In the council's submission, nothing heard during the inquiry provides a proper basis for departing from that strategic judgment. The proposal conflicts with the development plan. That conflict attracts substantial weight, and the appeal should therefore be dismissed. And Madam, you are respectfully invited to dismiss the appeal. And following on from these closing submissions at the end is an appendix which just sets out submissions in relation to the housing land supply sites, the disputed sites. I don't propose to read that out, Madam.
Noted, thank you very much. I have noted Appendix 1 as well. Mr. White, I trust you're content that Appendix 1 isn't read out in full?
Absolutely. Absolutely, Mum.
Great. Okay. Well, in which case, I recall that you wanted 10 minutes at least to finalise your closing submissions and send them over, Mr. White. I'm content that you do that. So, shall we resume at 12:15? Thank you very much. Thanks all for coming back promptly. I apologise that I wasn't back on time. My computer decided to drop out of the meeting just as I intended to get back in, but what's the Teams meeting if you don't have any technology failures, eh? So, can I check, please, Ms. Lambert, do you have Mr. White's closings?
I don't, but that shouldn't be a reason to delay anything if they have been sent.
I received yours when we were on about page 2 of your closings, so that was useful, but I haven't received Mr. White's either. What time were they sent, please, Mr. White?
Well, I sent them to those instructing me at 11:49, so hopefully they were sent to you soon after. I've just sent it to my learned friend.
I've received it, thank you.
Thanks.
And I'm quite happy if you remind me, Mum, of your case officer. If I've got the address, I'm quite happy to send it directly.
So it's Alison Dyson.
No, but I'm sure I can get the address. Let me just look in this file.
It is simply alison.dyson@planninginspectorate.gov.uk.
Sorry, could you just...
Yep, magic, I've received them.
Brilliant. Brilliant.
We are a go-go whenever you're ready, Mr. White.
Thank you very much. Mum, I've set out, if you've got it in front of you, at the first page is just the structure of this closing. I just noticed on section at the very bottom position, appendix 2 is the position of the parties on the planning balance, but that came in as ID 7 and I hadn't attached it because there's no evolution from ID 7. So don't be worried that you haven't got the full version because there's no appendix 2. So can I start off with the core case? And Mum, after 2 days of evidence, we say the following propositions support the appellant's case. And unlike amazingly what you haven't heard from my learned friend, there is actually a critical and overwhelming housing crisis in the UK currently that will only be effectively solved by the granting of additional consents to housing now. And this is not an academic debate that is a lawyer's fest, but a reality affecting millions of people currently and heartbreakingly for many children forced to live in substandard and temporary accommodation. This inquiry and appeal are not, frankly, about winning or losing, but providing a real solution that is materially causing distress and harm to those of the receiving end of the failure of over many years to provide enough housing. This site has been examined at great length over numerous years, and now remarkably in June 2026, there is no development management issue that precludes its development. The only issue now in the reason refusal 1 is an allegation of harm to an outdated spatial strategy. The LPA should, frankly, have supported this site at this appeal and not sought to promote a case which directly contradicts what has been said to members in the context of the reviews of LPP 1 and 2, namely that seminal and most important policies in the extant development plan are now out of date. Elements I'll come back to, but completely ignored by my learned friend's closing. We also say, for the reasons you heard on Wednesday afternoon, that this is a local authority that do not have a 5-year housing land supply position. The consequences of those two factors, out of date because of the change in the housing requirement and the HLS, requires you, frankly, in the light of the NPPF, to conclude the development plan is out of date and the application of the tilted balance should take place. The tilted balance must, frankly, mean something and should have effect contrary to its application by Miss O'Neill, where the application of the tilted balance, frankly, is meaningless. the benefits of this proposal that are before you, even on Miss O'Neill's assessment, are substantial and numerous. The impacts, in contrast, are limited and not weighty to an out-of-date development plan, a small amount of agricultural land, and to a minor localised limited landscape character harm, which does not justify a reason of refusal on the LPA's case. There is a remarkably almost no third-party objection. Only one resident has come to this inquiry, and he lives absolutely adjacent to the proposed site. Frankly, it is incredible how small the level of objection to this development of a greenfield site for 249 homes is. We say in introduction that the planning balance is overwhelmingly in favour of the grant of permission in this case. So section 2, ma'am, I deal with the housing crisis, which frankly, if I didn't speak, you would not have had a sense of, but of course you do. But there is a housing crisis nationally, regionally and locally for market and affordable housing in Britain today. There is a strong reality outside this inquiry that England must, not should or might, but must build far more homes. Because, as said by the government, not by the appellant, the government and the Minister of State for Housing just 6 months ago, England remains in the grip of a housing crisis that is both acute and entrenched. The detrimental consequences of this disastrous state of affairs are now all pervasive. 1.3 million people languishing on social housing waiting lists. And ma'am, I do stress to just spend a moment to think about that quantum, 1.3 million people. More than 170,000 homeless children living in temporary accommodation. And finally, as the Secretary of State said 2 years ago, we are in the midst of the most acute housing crisis in living memory. And the government have said to LPAs, and I'm sure the letter arrived by the Vale, not that you'd know from my learned friend's closing, but the government's core objective of delivering a target of 1.5 million new homes within the term of this Parliament. And this council, I mean, again, it's surprising, but when you hear the closing, but this council's aim in their forward to their local plan is providing more homes will help make housing more affordable and available and help provide people build their lives and families in the Vale. The first strategic objective of the development plan is to provide for a range of homes across the district to deliver choice and competition in the housing market to meet the identified need, including for affordable housing. And finally, the objectives of the policies of the plan is to support the delivery of a substantial increase in the supply of homes and traveller sites by ensuring that a sufficient amount and variety of land can come forward where needed. And ma'am, it's not for this inquiry and certainly not for you to question or debate government policy, but to implement it. And it is critical to note that it would be open to the government in formulating policy in the NPPF to decide not to meet that housing need in full, or even to ignore it, or actually grasp the nettle and seek to meet it in full. And there can be no doubt that the government has taken the most unambiguous position by determining that it must use the planning system and through the expression of planning policy to meet the housing need in full. The next point I seek to make on behalf of the appellants is that this is a superb site for housing. It's eminently suitable because it's agreed it's not located anywhere near a green belt, it's not within a conservation area, and it doesn't sit within the setting or sit near the setting of any listed buildings. Also, you have not any issue with national landscape or any local landscape designations. Secondly, entirely within flood zone 1, does not have known surface water flood risk. Additionally, no protected trees or hedgerows. Thirdly, we're dealing with a settlement identified in this council settlement hierarchy as a larger village. That identification identifies it as one of the more sustainable settlements in the district with a range of facilities and services. Fourth, we have a site where the bus stops are literally outside. They couldn't frankly be closer. The bus stops are also well served with a regular service that has a 20-minute frequency, and it takes 25 minutes to get to Oxford. It also, that bus goes to Farringdon and Swindon, and we say there's an exceptional level of public transport accessibility for a larger village location. Fifthly, it's common ground that greenfield sites will be required to address the district's housing needs. We know that this council have already allocated substantial greenfield land to the east for residential development, and outline planning permission has also been granted for that development. It is therefore accepted that greenfield development around this settlement is appropriate. Indeed, you know from LPP 1 and 2, the LPA have allocated over 900 units for such development. We also say the appeal site forms a logical extension to the existing settlement. It's surrounded by strong defensible boundaries and forms the logical extension to the village. The site's northern boundary is formed by the dual carriageway, which you saw, providing a strong and permanent boundary to any development. It is remarkable for an edge of settlement greenfield site to effectively have no landscape objection, but that is reflective of what one finds in the site's context. Seventhly, there are no objections before you on grounds of air quality, noise, transport accessibility, highway safety, highway capacity, drainage, flooding, residential amenity or ecology. There's simply no technical issue which has not been resolved by the proposal. Again, an incredibly rare situation when a proposal has no development management issue against it. Eighthly, it's agreed, subject to mitigation, the proposal would not result in a severe residual cumulative impact on the local highway network and the access is acceptable in every way. We say the site could not be more suitable for residential development. And the only question which remains, therefore, is whether the identified harms, which principally allege conflict with the spatial strategy, are sufficient to significantly and demonstrably outweigh the benefits. Mum, as you know from the evidence last week, there were 8 reasons of refusal. Through the work done by the appellant and the evolution of the Statement of Common Grounds and the 106 you dealt with this morning and the conditions, we are now agreed that reasons of refusal 2 to 8 have fallen away. That leaves the only reason of refusal 1 that alleges a conflict with the spatial strategy and those 5 policies listed. In addition, the council raises, well, I'm not sure the council, Miss O'Neill raises settlement form and function as new matters in its proof, but those were not reasons in the reason of refusal on the statement of case. It is quite clear they were added at the proof stage. They should be disregarded, frankly, because she has no authority through the reasons of refusal for such contentions. And frankly, if they were good points, which we don't accept they are, they should have been made in the 18 months the LPA were considering this matter. Can I just spend a moment on the approach of the parties, because my clients have engaged proactively and constructively through the planning application and appeal process. There was extensive pre-application inquiries undertaken. The application was submitted, and through the determination period, additional information and amended documentation was submitted in respect of consultation responses. The design was informed by a comprehensive landscape and visual impact assessment. There were ecological surveys, a transport assessment and archaeological investigations, as you've heard. The site was also promoted through the joint local plan and, frankly, the emerging plan. The appeal site was identified in the evidence base and the HELA that the site is appropriate for further consideration. Whilst the proposal being considered by the LPA, again, numerous matters were submitted. Since the refusal, there's also been working diligently to resolve the outstanding matters, and you know of all of those. We say, in contrast, the approach of the LPA has not been objective or applied government policy frankly or fairly, because the first flaw in the LPA's position is there's been no effective or fresh planning balance carried out by Miss O'Neill. And Mum, just think about this from your perspective as a planner. If you have a situation where 87% of the basis of objection is removed on your own case, you need to undertake, one must do a new and credible planning balance reflecting that. You have had no indication of any kind that that's been done by the LPA in this appeal. Secondly, the approach that was articulated last week to section 38.6 is incredibly wrong in law and practice. And can I just add an oral point? I'm going to breach, but I completely do not accept my learned friend's characterization of it as a mathematical exercise. Because what you have from the LPA is Miss O'Neill simply did not consider in her evidence or orally any policies that were neutral or supportive of the proposal. It's common ground. And this isn't a mathematical exercise, it's what the law requires. You identify the policies that are relevant, And what she did was only identify 6 policies in her proof, the 5 in the reason of refusal, and then slightly eccentrically CP7. Nowhere in her balance, before she concludes the proposals contrary to the development plan, were policies such as CP24, which are pretty important when you seek 80 odd affordable housing units justified by a policy requirement. But when it comes to section 38.6, completely ignored. It is inevitable, as I put to her in trite, that if you only grapple with 5 policies that you say are breached, you will arrive by definition at an intellectual destination of refusal. It was noteworthy that even when tested, she felt such an approach was appropriate and correct. It's obviously very rare indeed that any proposal doesn't breach any policies, certainly not on an LPA perspective, and the O'Neill approach, frankly, would always result in refusal. The third fundamental flaw is, of course, the extent of double counting in her planning balance. When she got to impact, she accepted that settlement form and function fell within the gambit of reason of refusal 1, and yet she had it down as 2 additional impacts. Frankly, it can't be utilised again in any credible balance exercise if it falls within the first impact, save solely to bolster a fragile case. That was exactly what was done. The fourth fundamental flaw was underweighing benefits. In the light of the expressions of government about the importance of significantly boosting housing, to give a scheme of up to 249 units any moderate weight was just remarkable, particularly as Mr. Duval had identified elsewhere she'd recently given it substantial weight in an inquiry in December 25. The fifth fundamental flaw was making redundant the tilted balance. Her approach and conclusion was identical whether the flat or tilted balance was applied. It had no effect whatsoever on her balance, which makes that policy mechanism a centrepiece of the government, OTOs and redundant. And lastly, considering the policies being out of date in the context of the tilted balance, but applying because of no HLS and yet applying exactly the same weight, that is betrayed in her para 1025 when it's concluded in the context of the tilted balance that the benefits do not outweigh the identified conflict with the development plan. And ma'am, the operation of NPPF 11 must be consequential. Of course, it is open to still in law give substantial weight to such policies, but is such an approach genuinely reasonable if you concluded such policies are out of date? The practical effect is shown if you take her approach in her evidence that even if there be a shortfall, even if this LPA do not have an HLS, planning permission should be refused. Therefore, she does the remarkable thing of achieving exactly the opposite of what the government's trying to do, which is to get planning permissions in such factual situations. And ma'am, I ask you to compare her approach with that of Mr. Duval, who did the opposite of the above and was far fairer and objective, and his evidence utterly withstood any challenge in cross-examination. So can I then deal with the legal and policy framework? And I think, ma'am, just importantly, I don't think I need to read 29 to 32 because I'm sure most of that is completely ingrained on your psyche as a result of your caseload. But what is important, it is common ground that there is no matters that are asserted to disengage the tilted balance. So can I deal with the fundamental, and this is probably the most critical point you have to grapple with in your decision letter, is the development plan and whether it's out of date or not. The LPA in their case to you seek to convince you it's up to date. Remember the evidence of Miss O'Neill. The relevant policies of the adopted development plan remain up to date. She says this in terms of 6.7, and my learned friend reiterated that in opening. Conflict with an up-to-date policy is in NPPF terms an adverse impact. This is obviously critical because NPPF 11D activates the tilted balance where policies which are the most important for determining the application are out of date. So that is the test of whether the most important policies are out of date. And the spatial strategy is agreed was formulated in the context of a requirement of 1,028 dwellings per annum. That was the objectively assessed need at the time of adoption. The current standard method, LHN, is 949, again agreed. So the local plan was designed to deliver those homes through specific allocations and windfalls. And of course, the plan is now more than 5 years and the allocations are largely committed or built out. The spatial strategy policies, CP3, 4, 8, CP4A and CP8A were designed to work in the context of a plan that was meeting its housing needs. Where the plan can no longer demonstrate a 5-year supply, as is our case, those policies are rendered out of date by operation of footnote 8, and the weight to be attributed to them in the planning balance must be reduced accordingly to Suffolk Coastal and Hopkins Homes. Even where the tilted balance is engaged, those spatial strategy policies are not rendered irrelevant. We accept that as a result in Gladman, but they must carry reduced weight because the weight to be attached to them is a matter for you, the decision maker exercising planning judgment. But we say for 3 reasons in the clearest terms the development plan is out of date. And the first is not us, but the LPA have consistently and repeatedly concluded the plan is out of date. And of course, what's remarkable about all this section, does it figure or does it get mentioned in my learned friends closing? Not at all of it. But this is, first of all, you know from Mr. Duval's cross-examination on Thursday, the review, this council did a review in December 21, and it's fascinating what they concluded in the light of my learned friends closing. They utilise a red moniker if a policy is out of date. CP4, half of it has red. It is said in terms the housing requirement requires updating. Not Mr. Duval saying this, the LPA. It simply cannot credibly be said that the plan is up to date when the council have concluded, and Mum, this is important, not in the context of some review in a pub, but in a document to their members complying with a requirement in law that the housing requirement requires updating. It's also accepted that CP5 requires updating, and it's no longer consequently used for monitoring purposes. Again, this conclusion of the council is highly important because they've changed the basis of monitoring housing land delivery from that set out in LPP1. Again, it cannot credibly be said the plan is up to date in those circumstances. It then goes on, that review on page 10, to say about CP5. In the meantime, for monitoring and housing land supply purposes, the district-wide figures will be used in line with national policies, i.e. the ring fencing has been ditched in LPP1. Again, it cannot credibly be said the plan is up to date when the way they monitor and consider housing land supply differs from LPP1. Then we have Appendix 1 of the review on page 49. Again, not the appellants. My learned friends' clients conclude to members, since the adoption of the plan, the national policies for calculating housing need and housing requirement have changed significantly. That's their conclusion. The housing requirement has changed significantly. It then goes on to say, a new local plan would be tested against different national policies and guidance from those in place at the time of LPP1. Combined with the 38% drop in need indicated by the local housing need assessment, this is compelling justification that the housing requirement element of core policy 4 requires updating. Again, it cannot credibly be said that the plan is up to date. Point 7 from the review, taking due regard to all the factors together on balance, the council concludes, and Mum, I would ask you, I don't know if you've got a physical copy or electronically, but note, the council concludes that the scale of divergence is decisive in determining whether the housing requirement should no longer be regarded as an up-to-date reflection of needs when it is so far removed from the current local housing need figure. And lastly, Appendix 1 to the review at the end said, the housing requirement in core policy 4 therefore needs updating. So 8 times in the review of December 21, the LPA addressed their minds of whether policies are up to date, conclude clearly, without any ambiguity, they are not, for the reasons set out there. Then, did Wiser Council, was my learned friend's case embraced by September 24? No, the opposite. The second review of LPP2 in September 24, again, Mum, you will note, carried out by officers of the council, not the appellant, the officers of council, and it says, we no longer consider policy 4A, yes, a policy they rely on this appeal again. We no longer consider this a sound basis for housing need in Appendix 1. Policy CP4, again, it's said elsewhere, needs updating. It's also said, and my learned friend said we didn't contend this, we didn't need to, because the conclusion of her own officers was that CP4A is no longer consistent with national policy. It then gets better. Policy CP8A needs updating. Then we move on to the statement. Remember the report to the Cabinet. An officer obviously read the review of September 24 and summarised it in a Cabinet report and says in terms that CP4A and CP8A need updating in September 24. Then we have the delegated report dealing with this application. And again, it's identified that the review shows that if you go on, it says, acknowledges that CP4 required updating by association CP5 found to be inconsistent. Consequently, CP5 no longer used for decision making and monitoring. And then finally, in the LPA reported in their 23-24 AMR, at para 3.6. However, the review identified the housing requirement in 4A needs updating, that 4 and 4A require updating, and the Council's review require that CP4 requires updating, and so Core Policy 8, which derives its sub-area target from Core Policy 4, cannot be monitored. Therefore, you have the extraordinary position that in June 26, the LPA contend, as my learned friend did forcibly, that the 5 most important policies here, which frankly are all in the reason of refusal that remains, are up to date. Yet the LPA in other forums and other contexts of a Regulation 10A review have consistently conceded that 4 of those policies, 4, 4A, 8 and 8A, are out of date and require updating. And that conclusion was presented to members and endorsed by them. Additionally, one of the 5 core policies identified in LPP1, CP5, has been jettisoned and accepted out of date. Therefore, for the LPA, the position is that for 4 years they've concluded that 5 key policies are out of date. 4, 4A, 5, 8 and 8A. And in terms of the MPPF paragraph 11, Mum, that is absolutely conclusive that the plan is out of date. And any contention, as you've heard this morning, I mean, you've got to admire the LPA's case for courage, frankly, in the light of what they previously conceded. But I ask you to reject in the strongest terms any contention that it's up to date when the complete opposite has consistently been said to members, and it doesn't reflect well on the LPA. Solely, as usual, to win this inquiry, they deploy arguments which contradict very important judgments previously reached, set out to members and endorsed both in December 21 and September 24 in Regulation 10A exercises. The simple point is the reasoning that underpins those conclusions that were shown to members, the basis for calculating and assessing housing need have fundamentally changed since 2016, necessitating such policies and matters are updated. The second reason is the HLF position, and the parties agree that the policies set out in those 2 plans are more than 5 years. They also agree on the standard method of calculation, and there is agreement on the requirement. Obviously, the only dispute relates to supply, and particularly the category 7, the 7 category B sites, which the appellant, Mr. Neame, contends should be excluded, and that should lead you to a deduction of 871 requirements. Ma'am, I will follow, the only thing I will follow, my learned friend, I will take para 48 as read, and you can reflect on that. It's not particularly exciting or worthwhile to read out the details of each site, but you have there a record. So if I could ask you to go to page 19, and I'll go to the third reason, which is the age of the plan. And I make the following points. We make a third contention that the age of the plan makes it out of date as well. Because for the LPA, as my learned friend did in opening, she sought to beguile you with a submission that this is a relatively recent development plan. Well, if someone described something that happened 10 years ago and said that was recent, I think your immediate reaction would be that's a surprisingly elastic use of the word of what recent is if it's 10 years ago. But we say that's an exaggeration because, as you have noted and will know, significant developments taken place. in the district, significant development in KBS, like the two allocations which are coming forward, the one that's built out and the reserve matters for 600 units. We've had this minor matter of 4 national planning policy frameworks since that time. There's been the change which I've just dealt with in the housing requirement. There's also looking at the future and the present. The LPA have ditched their unitary place and they're preparing a joint plan. And what was said in the LPP review, when the LPA said that the context for the joint local plan is different from LPP1 and LPP2, with new corporate plans for the Vale and South Oxfordshire Place, as well as the Oxford plan being prepared. Obviously, the decision of the LPA to ditch the ring fence concept to assess housing need is pretty powerful. And lastly, the decision to bring forward an updated plan. So there's a third reason that the plans are vintage and out of date. Therefore, putting those 3 reasons together, the position of the LPA, the HLS position and the age of the plan provide compelling justification for you to use applying the test in NPPF 11 that the plan is out of date. And to conclude it's up to date and conversely would be to reject the LPA's own position consistently held elsewhere that they've told their members for many years, solely in the confines of this planning appeal. Therefore, we say, as a result of that clear conclusion, ma'am, the tilted balance is in play. And for those reasons, we say the tilted balance is a conscious and meaningful attempt since 2012 to assist housing delivery and make it intentionally more difficult to refuse planning permission that seek to build housing where the LPA have inadequate supply. It must have an effect and consequence to be a meaningful part of policy. And of course, the aim of the presumption is to incentivise local authorities to get on and take decisive action to meet housing needs. And it is the intention of government that it intentionally, explicitly creates a high bar for refusing planning permission for residential developments. Of course, whilst you need to reach a judgment on each case, it must be exercised in the context of metaphorical scales, which are pre-weighed by definition in favour of the grant of permission. Otherwise, this key plank to address the housing crisis would be entirely ineffective, as Miss O'Neill has sought to do. Of course, the December 2024 NPPF has reinforced this position further, and of course, Para 11D2 now requires the decision maker to have particular regard to key policies for directing developments to sustainable locations, which has a tick here, making effective use of land, which has a tick here, securing well-designed places, which will have to be addressed in the reserve matters, and providing affordable homes individually or combination, which gets a tick here. Therefore, the appeal proposal clearly satisfies one of those key tests in 11D2. There's also the point, ma'am, there's no solution to the crisis I've identified other than granting permission now. Obviously, the HDT historically shows 177. However, of course, we need to look forward, not backwards. And the joint local plan, as you heard from Mr. Neame, is seeking to meet, remarkably, 76% of its current standard method LHN. As a result of the amended position, it's now only 72%. Therefore, Para 236 of the framework will apply, and this council's in a remarkable position while promoting the joint local plan that they will need to begin work immediately on a new plan. So the emerging local plan is not an answer to the housing land supply crisis. We also say, as you've heard from Mr. Neame, that that local plan is completely failing because it fails to meet at least 5,500 dwellings as set out in the HLN, which the massive shortfall which the council's rebuttal does not challenge. The emerging local plan, of course, is an examination, but we say when you look into the past and look at what has been done against the adopted local plan, we completely reject the sunshine and light approach from my learned friend that everything is happy, well-performing local plan, because as Mr. Neame identified, actually you've got a shortfall of 3.83 dwellings against the plan requirement, and a shortfall of some 2,992 dwellings against planned supply. And those figures are a material consideration in terms of the adopted local plan. There is therefore no adopted plan on the horizon which will address the housing requirement in a timely fashion. And as you've heard, there were regulations. I'll jump on now because I'm telling you things you already know up till paragraph 79. So can I deal with the benefits of the proposal? Ma'am. The first is, of course, the delivery of up to 161 market homes in a district where we say there's a demonstrable need for housing and it should carry substantial weight. The greater the shortfall, the greater the weight should be given, and the council's own evidence accepts that the delivery of market housing is a significant benefit. I think its moderate significant was agreed by Miss O'Neill in her cross-examinations, reflected in how my learned friend puts it in closing, in a tilted balance world. Then we have 88 affordable homes, accords with policy CP24, and the split in those 22 first homes. Think about that if you grant consent, ma'am, 22 first homes to those that have never had a house before, 22 individuals, couples, families will have a first home. 49 will be affordable rent and 17 shared ownership, making people get on the ladder. The joint housing needs assessment, as Miss Gingle identifies, there are 2,663 households where there is a need emerging. That's not people, households, equating to 133 households per year. As a result of a freedom of information request, it shows that some people in Vale are waiting 11 years for a 3-bedroom property, 9 years for a 1-bedroom home. And frankly, it takes a moment, and yet we get my learned friend's closing that everything's sunny and delightful in the housing provision of this district. There's also an acceptable offer from a registered provider. Therefore, the delivery actually of 88 affordable homes will transform lives, and we ask you to give that substantial weight. There will be economic benefits through building off the construction phase, the employment that will generate, the spending by those that live in the houses. The occupation phase will bring spending to KBS. These aren't merely generic benefits, but they are detailed and quantifiable, and that should carry significant weight. It's a sustainable location for the reasons I've already said. That should carry moderate weight. There will be a BNG which will be confirmed at the reserve matter stage in excess of 20%. Also significant environmental benefit, significant weight. Public open space and recreation. 45% of the site will remain as open space or landscape. Provision of new footpaths, existing rights of way will be enhanced, will improve connectivity, again, moderate weight. Financial contribution towards local services and infrastructure, moderate weight. So taking those 7 benefits together, they are weighty, and we ask that you give those substantial weight in the planning balance. If you only look at the benefits individually, it is by definition impossible to underestimate the overall weight on the benefit side. The cumulative weight of those matters taken together, however, is compelling. Then let's deal with the 5 impacts that I think the LPA are contending exist. The first is the spatial strategy, but we simply don't accept that for the reasons I put to Miss O'Neill on Thursday morning, ma'am. The first is, how can you breach a spatial strategy where the key point made in the forward of the plan seeks to provide more homes? How can you breach a spatial strategy where the housing requirement is a minimum? How can you breach a spatial strategy which seeks to promote thriving villages? We've also got the point of out of date, which I won't deal with now. We've also got the point that, of course, that KBS has been chosen in that spatial strategy to have 885 units granted permission. It also complies with the strategic objective for a range of homes agreed in cross-examination. It complies with the second strategic objective by meeting existing and future residents' needs. It meets the third strategic objective by using one of the most sustainable locations in the district. It meets the fourth strategic objective to reduce inequality, poverty and social exclusion. It complies with the fifth strategic objective, which assists a strong economy. It complies with the 9th strategic objective, allowing for effective transport choices. It therefore, as was agreed in cross-examination with Miss O'Neill, complies with 6 strategic objectives. It also complies with the spatial strategy, which is repeated on page 36, of at least a minimum of 20,560 homes. It also complies with the spatial strategy, which is the first sentence, which is again repeated on page 37 to support delivery of new housing. It also, there are 3 key strands of the spatial strategy, which includes focusing, and think about this, ma'am, how it is contended by the LPA this breaches a spatial strategy which seeks to focus housing growth at larger villages. and larger villages are clearly, unambiguously part of that spatial strategy. Also includes supporting strategic housing growth at KBS on page 39, and it seeks to focus development within the rural areas on larger villages. So again, the absolute focusing on larger villages. The actual allocations set out in LPP1, only 4 are for larger villages, of which KBS is one. The settlement hierarchy identifies this settlement, and it's accepted to be a highly sustainable location and growth within larger villages. Therefore, when you amalgamate those 22 reasons together, we say it's just not credible to say the grant of permission here would breach that spatial strategy. The priority of the development plan is to put housing and growth in the most sustainable settlements, which this proposal does. Then the council argued that somehow the proposal will contribute to cumulative outward expansion. However, of course, you have a position in the east, 660 homes. That was considered acceptable and allocated. We're obviously on the opposite western side of the settlement. There is no genuine coalescence either with the eastern allocation or anywhere else. The settlement has grown historically, as is most true of most settlements in the UK, and we say growth to the west is a natural continuation of that pattern. Also, there will be strong boundaries to the north A420, to the south Spring Hill. On the western boundary, the boundary vegetation you've seen in the illustrative master plan. They will be strong and defensible boundaries. In the context of the tilted balance, we say the conflict with a spatial strategy should be limited and have limited weight because it would not undermine a functioning up-to-date plan. It is the case, for the reasons I've said, the plan is out of date, the housing requirements changed, and new sites are now urgently need to meet housing needs. Then landscape character and visual amenity. Mum, I will jump on, I've got those points, but if it's not a major issue, could I go to paragraph 91 and just make the point that it is agreed that the landscape and visual effects of this proposal are no greater than moderate, as the council's own landscape officer agreed, and they are highly localised. That level of harm for a greenfield site is entirely proportionate and acceptable in the context of the overwhelming need for housing and the tilted balance. Then the loss of agricultural land, it's accepted that 3.3 hectares are grade 2, but the loss of those 3.3 hectares does not accord with policy CP43, as Mr Duval always accepted, but is not a reason for refusal, even on the council's case, and we say should only have limited weight. Then can I deal with one of the 2 additional O'Neill points, cumulative growth? The council argues the proposal would contribute to cumulative outward expansion. And again, I've dealt with the boundaries point, I've dealt with the coalescence points. Again, I've made the point that the harm only emerged in the proof and has no policy basis, and we say you should give it no weight. Exactly the same, for the same reasons, can be made to settlement function. So overall, Ma'am, when you're considering in your balance the 5 impacts, we say, taken together, they are modest. Out-of-date spatial strategy should get limited weight at most. Localised landscape harm should get moderate weight at most. Loss of small agricultural land, best and most versatile, limited. Can I just spend a moment on the third parties? There have been 32 objections to the application, and we say, given the scale of the proposal, this is a very low number of objections. Only 1 representation was received in response to the appeal, which was from the parish council. And we say the matters raised do not alter the conclusions of the evidence that Mr Duval has called. Can I just make a few points penultimately in relation to the closing of the LPA? The first point is, I mean, my learned friend starts off with a bit of jury advocacy by saying it's a suburban mass housing development. Well, there's not a shred of evidence to make that allegation to justify it. There's no challenge of any kind to the proposed design, materials, density, layout or appearance of the scheme whatsoever in the LPA's case. Secondly, my learned friend's been incredibly versatile. She's now developed, she's got the O'Neill illness of developing an argument on her own, completely unargued by a planning witness, that somehow the spatial strategy, the thing you should focus on, is this point about the sustainable growth of the science fair. Indeed, it takes up 8 paras of her closing. Actually, the key to the breach of the spatial strategy is an allegation that somehow you're harming or contrary to the science fair focus in the spatial strategy. That point has no basis in the officer's report, the reasons of refusal, the statement of case, or the planning proof. Indeed, it was developed for the first time in the cross-examination put to Mr. Duval, and in closing, and frankly, it's my learned friend's contention alone. I ask you to reject it for that reason. Frankly, it's also wrong. It's also remarkable that there's an attempt at Paris 81 and 85 to somehow get you to believe that Miss O'Neill's Section 38.6 exercise is credible. The fact that there was 34 of the 40 policies were completely ignored is incredible, and the fact that the LPA seeks to place weight on that approach, which ignores the law, is incredible as well. The level of importance placed on the breach of policy 43 is betrayed by the fact it was no part of the reason of refusal. And also, again, we've got this position where you are asked to give the development plan substantial weight. But we say that is wrong for the reasons I previously dealt with. But also, it's contrary to the importance of you give it the same weight, whether it's out of date or up to date. What's the incentive? I mean, think about this intellectually, Ma'am. Why is there any incentive on a council to have an up-to-date development plan if it doesn't make a jot of difference to the weight you attribute to policies, whether they're up to date or out of date? And what is the purpose of MPPF 11 and the consequent deployment of the tilted balance if whether a plan is out of date or not still results in substantial policies being given to those policies? So it makes a mockery of the test the government have of being out of date. It makes a mockery of reducing weight if you don't do that. It makes a mockery of the tilted balance. Also, we have the failure to redo the planning balance completely ignored, and of course the consistent conclusions of the LPA elsewhere about the plan and out-of-date policies is ignored. So finishing for the appellants, Ma'am, the overall conclusion, as you well know, the starting point for you in this determination is section 38.6, which requires you to look at the development plan and other material considerations. It is contended by the LPA critically that 5 policies are breached, but it is also correct that the DP is actually complied with, as Mr. Duval says, when you look at the plan as a whole. And it is reasonable to give the 5 breach limited weight when the council have concluded that effectively those policies and the spatial strategy is out of date and must have reduced weight. For the reasons set out, the policies are out of date. There are no footnote 7 matters that disengage the tilted balance, and therefore the fundamental question for you is whether the adverse impacts significantly demonstrably outweigh the benefits. We say that they don't, because of course you have the benefits I've outlined, which are set out, most of which are agreed. The only disagreement goes to weight. On the other side, you have the conflicts which are said to the spatial strategy, the landscape harm, and the best and most versatile agricultural land. It's submitted that those simply not possible to conclude that those 3 impacts significantly demonstrably outweigh the benefits, even when you deploy the weightings that Miss O'Neill uses. We say that the tilted balance operates decisively in favour of the grant of permission in this case, as intended by the government to ensure delivery of housing where it's required. It's also consistent with approaches taken elsewhere in comparative appeals like Childgrove, where 160 units were allowed in South Oxfordshire in the neighbouring authority, concluding that the benefits outweighed the harms. So, Ma'am, for those reasons, and in concluding the appellant's case, we say the case for the grant of permission is very powerful and compelling. And those are the closing submissions of the appellant. But I do ask you at your leisure also to spend a bit of time at Appendix 1 and have a look what's said about the relevant policies, whether they're in a reason of refusal, what weight they should be given, and what the appellant's position is to whether there be conflict or not. So those are the closing submissions of the appellant. Thank you, Ma'am.
Thank you very much, Mr. White. I will do as asked and take some time to review the appendices that haven't been read in full. So unless there's anything else that I need to deal with, I can happily confirm that we are closing the inquiry now. And you will recall our discussion earlier about the timetable for the submission of the documents as agreed. So unless anyone needs any reminders on those, I am happy to sign off now.
Thank
Okay.
you, Lambert.
Well, thank you for your participation, everyone. The inquiry is now closed.
Thank you.
Thank you.